Greetings, students. I hope that you're all doing well. In the last lecture, we discussed Section 2, Section 3, Section 4, and Section 8 of the Indian Contract Act of 1872. At the same time, we also discussed various MCQs and mains-based previous year questions that have been asked in relation to the same sections. In this lecture, we would be continuing with Section 4 and completing the first chapter of Indian Contract Act of 1872 as mentioned in the Bare Act. So as you can see on your screen, Section 4 says that communication when complete, the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. The communication of an acceptance is made as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor as against the proposer when it comes to the knowledge of the proposer. The communication of revocation is complete as against the person who makes it when it is put into a course of transmission to the person to whom it is made so as to be out of the power of the person who makes it as against the person to whom it is made when it comes to his knowledge. So as we can see over here that the Indian Contract Act in Section 4 adopts a rather peculiar modification of the rule. According to the section, when a letter of acceptance is posted and is out of the power of the acceptor, the proposer becomes bound. But the acceptor will become bound only when the letter is received by the proposer. So as I mentioned earlier, there have been a lot of categories of cases which can become a potential question in the coming examination. So we would be covering all such potential scenarios, all such potential categories of cases which have led to evolution of different sections as we deal with these sections. So under Section 4 there are many such categories of cases. So to begin with, the first category is a scenario where the communication is done to the offerer himself. So the acceptance must be communicated to the offerer himself. A communication to any other person is as ineffectual as if no communication has been made, and the same has been held in Feldhaus versus Bindley, whereby the fact says that the plaintiff offered by means of a letter to purchase his nephew's horse. The letter said, "If I hear no more about the horse, I consider the horse mine at 33.15 pounds. To this letter no reply was sent, but the nephew told the defendant, his auctioneer, not to sell the horse as it was already sold to his uncle, and the auctioneer by mistake put up the horse for auction and sold it. So the plaintiff sued the auctioneer on the ground that under the contract the horse had become his property and therefore defendant's unauthorized sale amounted to conversion. But the action failed. And the reason why this action failed was because, as the court said, it is clear that the nephew in his own mind intended the uncle to have the horse, but he had not communicated his intention to the uncle. So the case is also an authority for two further propositions. One of them is that the acceptance of an offer made should be communicated to the offerer himself or to the person he has authorized to receive the acceptance. That is, a communication to a stranger like the auctioneer in this case will not do. And secondly, that offer cannot impose burden of refusal. Now, it is very important to understand this concept, that the offerer cannot say that if no answer is received within a certain time, the same shall be deemed to have been accepted. It is not open to an offerer to stipulate against an unwilling offeree that the latter's silence will be regarded as equivalent to acceptance. He cannot force him to take a positive course of action under penalty of being contractually bound if he does not. So that needs to be very clear as of now, that offer cannot impose burden of refusal. Now moving on, another category of cases comes under communication by acceptor himself. Of course, the natural corollary of this principle is that the communication of acceptance should be from a person who has the authority to accept. Information received from an unauthorized person is ineffective. So it has been held in Powell versus Lee that the plaintiff was an applicant for the headmastership of a school. The managers passed a resolution appointing him, but the decision was not communicated to him. And one of the members, however, in his individual capacity, informed him. So over here, the managers cancelled their resolution and the plaintiff sued for breach of contract. Rejecting this petition, of course, rejecting this action, the court said that there must be notice of acceptance from the contracting party in some way. So, information by an unauthorized person is as insufficient as overhearing from behind the door. So, that is another category of cases for which the authority is given, and if under in any of these cases, if any of these cases are asked in the examination, you must define the given law of the land by the given authority. That is, any case law that you may find, and in such a scenario, it is best to have at least one or two cases for any such category. It is important to be prepared for the examination. You never know which topic may be asked under a given section. So please adhere to the same and make a note of these case laws as they have been mentioned in the PPT for you. Now moving on, another category is when communication is not necessary. So in certain cases, communication of acceptance is not necessary. For example, it has been held in State of Bihar versus Bengal Chemical and Pharmaceutical Works Limited that the offerer may prescribe a particular mode of acceptance. And when this happens, then all that the acceptor has to do is follow that mode. And it has also been held in Malaraju Lakshmi Menayamma versus Venkata Narasimha Apparao that the offerer may have acquiesced in a certain conduct on the part of the acceptor as equivalent to acceptance. And in such a case also, no formal communication of acceptance is necessary. Then acceptance should be made in a prescribed manner. So the acceptance has to be made in the manner prescribed or indicated by the offerer. An acceptance given in any other manner may not be effective, particularly where the offerer clearly insists that the acceptance shall be made in the prescribed manner. And there is an American case law of Eliasson versus Hanshaw which illustrates this. In this case, A offered to buy flour from B, requesting that acceptance should be sent by the wagon which brought the offer. But B sent his acceptance by post, thinking that this would reach the offerer more speedily. But the letter arrived after the time of the wagon. A was held to be not bound by the acceptance. So this case law illustrates this given category, that acceptance should be made in prescribed manner. Now we would be talking about the Section 7 of Indian Contract Act of 1872. So Section 7 goes, acceptance must be absolute. In order to convert a proposal into a promise, the acceptance must be absolute and unqualified. Number one. And number two, it must be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. So, if the proposal prescribes a manner in which it is to be accepted and the acceptance is not made in such manner, then the proposal may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner and not otherwise, but if he fails to do so, he accepts the acceptance. So it is very important to understand the idea of this given section, especially the second part of this section, and we would be talking about it by different categories of cases which have led to its evolution. So on the idea of effect of departure from prescribed manner, we must understand that the section no doubt requires that acceptance should be made in the manner prescribed in the proposal, but a departure from the manner does not of itself invalidate the acceptance. That is, a duty is cast on the offerer to reject such acceptance within reasonable time, and if he fails to do so, the contract is clinched on him and he becomes bound by the acceptance. So the section marks a visible departure from the English law and should therefore be read without reference to the English law on the subject. There is, however, one advantage to the acceptor in following the prescribed mode. That is, by giving his acceptance in that mode, he has done all that the offerer required him to do, and he is entitled to the contract even if the acceptance does not reach the offerer. So, in PCSJ examination of 2003, UP PCSJ 2003, a question was asked in prelims, which of the following is a valid acceptance of a proposal? So, this question, I feel I have already discussed it with you in the first lecture, but I will be discussing it again since it comes under this section. So over here we must understand that when an acceptance is made in a manner prescribed by the proposal, that is a valid acceptance of a proposal. Now another category is where no manner is prescribed, and that in this category reasonable and usual manner is to be implied. So where no mode of acceptance prescribed, acceptance must be expressed in some usual and reasonable manner. That is the rule. That is the rule of law, the given law of the land for this section. But male is a very reasonable manner in such cases. In England, the rule is that where an offer is received through post, acceptance may also be communicated by post. But in India, and you must remember that in India, in view of the language of section 7, post may be used as a mode of communication in all cases where it is reasonable, except when the offer requires a particular form of communication. Now coming to the area of coming to the scenario where a contract is concluded with postal communication. So in such a situation, you must understand that when the parties are at a distance and are contracting through post or by messengers, the question arises, when is the contract concluded? Does the contract arise when the acceptance is posted or when it is received? So over here, a complete contract arises on the date when the letter of acceptance is posted in due course. So this rule was affirmed by the Court of Appeal in Household Fire and Accident Insurance versus Grant, and the facts of this case was that the defendant had applied for allotment of 100 shares in the plaintiff company. A letter of allotment addressed to the defendant at his residence was posted in due time, but it never reached the defendant. Nevertheless, he was held bound by the acceptance. In another case, that is ONGC versus Modern Construction and Company, the contract was concluded at the place from where the proposal is accepted, and communication of acceptance was dispatched. That is the address at which the proposal was sent. The court at that place was held to have jurisdiction to entertain a cause of action under the contract. So, coming to the difference between English and Indian laws on this given section, we notice that the only difference that the section makes is in the position of the acceptor. In England, when a letter of acceptance is posted, both the offerer and acceptor become irrevocably bound. But in India, the acceptor does not become bound by merely posting his acceptance. He becomes bound only when his acceptance comes to the knowledge of the proposer. So the gap of time between the posting and the delivery of the acceptance can actually be utilized by the acceptor for revoking his acceptance by a speedier communication which will overtake the acceptance. So we notice that the peculiarity of this rule is that after an acceptance is posted and before it comes to the knowledge of the offerer, only one party, that is the offerer, is bound. And the acceptor still has the right to recede from the contract by revoking his acceptance. Now coming to a scenario when parties are in direct communication. Now this rule that the communication of an acceptance is complete as against the proposer when the letter is posted is intended to apply only when the parties are at a distance and they communicate by post. Where, however, the parties are in each other's presence, or though separated in space, they are in direct communication, as for example by telephone, no contract will arise until the offerer receives the notification of acceptance. So this has been held in Entours Limited versus Miles Far East Corporation. The facts of the case was that an offer was made from London by Telex to a party in Holland and it was duly accepted through the Telex, and the only question was whether the contract was made in Holland or in England. So over here the Court of Appeal held that Telex is a method of instantaneous communication, and the rule about instantaneous communications between the parties is different from the rule about the post. So the contract is only complete when the acceptance is received by the offerer, and the contract is made at the place where the acceptance is received. And this case has been taken by the Supreme Court, whereby in a way it also approved the given judgment of this case. And in the Indian case in which the judgment of this case was implied was Bhagwan Das, Govardhan Das, Kedia versus Girdhari Lal Purushottam Das and Company. In this case, the plaintiffs made an offer from Ahmedabad to the defendants at Khamgaon. to purchase certain goods and the defendants accepted the offer. The question was whether the conversation resulted in a contract at Khamgaon or at Ahmedabad. So, the majority of the judges preferred to follow the English rule as laid down in the Antos case and saw no reason for extending the post office rule to telephonic communication. Justice Shah even said that the contract becomes complete when the acceptance of offer is intimated to the offerer. So the draftsman of the Indian Contract Act could not have envisaged use of telephone because it had not yet been invented, and therefore the words of the section should be confined to communication by post. This is what Justice Shah had to say while giving the judgment in the majority. So, this case was mentioned in UPPCSC examination of 2003, whereby in prelims a question was there that a contract through telephone is considered concluded at the place where acceptance is heard. In which of the following cases it was held? So students, you can see that direct questions are asked only if we make sure that we are able to complete the sections with the landmark judgments thoroughly. And lastly, on this given category, it has been held in Quadricon P Limited versus Bajrang Allowance Limited that fax communication, like telephonic communication, becomes complete when the acceptance is received by the offerer. In section 7, the idea of absolute and unqualified is mentioned, and we must emphasize upon the same, as the same becomes a pretty important principle. So, in order to convert a proposal into a promise, the acceptance must be absolute. So, on that note, we will be discussing the concept of counter proposals, as a part of which we must mention that in the case of Haji Muhammad Haji Jiwa versus E. Spinner, it was held that any departure from the terms of the offer or any qualification vitiates the acceptance unless it is agreed to by the person from whom the offer comes. In other words, an acceptance with a variation is no acceptance. It is simply a counter proposal which must be accepted by the original promiser before a contract is made. So the facts of this case in which this statement occurs were as follows. Before accepting an offer, the plaintiff introduced certain terms like free, Bombay, harbour and interest, which were not there in the original offer. This the defendant refused to accept. Subsequently, the plaintiff communicated his acceptance of the original offer, but the defendant did not assent to this. So here the plaintiff's action for breach of contract was dismissed. And the reason for the same was that, as mentioned by Sir Jenkins, that unless there is an absolute and unqualified acceptance, the stage of negotiations has not yet passed and no legal obligation is imposed. So the plaintiff's first acceptance with new terms was in fact a counter offer which implied the rejection of the original offer. And a counter offer puts an end to the original offer and it cannot be revived by subsequent acceptance. So in 2006, in mains, question was asked in UPPCSJ mains of 2006, question 10C, which said that B offered to sell his house to A for rupees 1 lakh. A replied that he is ready to purchase the house for rupees 90,000, to which B refused. Then A agreed to purchase the house for rupees 1 lakh. Is B bound to sell the house? So I want you to think while you process this question. I would give you 5 seconds to think about it, what you would write if you had a choice. Students, in the given problem, the reply of A that he is ready to purchase the house for rupees 90,000 is actually a counter offer but not acceptance. So subsequently, agreeing of A to purchase the house for rupees 1 lakh is a fresh offer to B which is not accepted. Therefore, B is not bound to sell his house to A for rupees 1 lakh. Now, continuing on the idea of partial acceptance, we would be talking about the case of Raman Bhai M. Nikam versus Ghazbi Ram Ladli Prasad. So, we all know that acceptance should be of the whole of the offer. That is, the offeree cannot accept a part of its terms which are favorable to him and reject the rest. Such an acceptance is another kind of counter proposal and does not bind the offerer unless he agrees to the qualified acceptance. So in this given case, it was held that where the facts were such that an application for certain shares in a company was made at the condition that the applicant would be appointed cashier in a new branch of the company, but the company allotted him some shares without fulfilling the condition and claimed the share money. Here it was held that the petitioner's application for 100 shares was conditional and that he had no intention to become a member of the company when he applied for the shares until he was appointed a cashier in the branch office. So this being a matter of partial acceptance, the court held that the company which allotted him some shares without fulfilling the condition and claimed the share money, that was uncalled for. Now continuing on the inquiry into terms of proposal, in UPSEB versus Goel Electric Stores, it has been held that a mere inquiry into the terms of a proposal is not the same thing as a counter proposal. So in a negotiation for the sale of a quantity of iron, the proposal was, I would now sell for ₹14 at cash open till Monday, and in this case the offeree inquired by wire whether the offerer would accept ₹40 for delivery over 2 months or less. You must notice over here that the offeree merely inquired, but the offerer, treating this as a rejection, sold off the goods. Here he was held liable for the breach. To seek an explanation of the terms is something different from introducing new terms, and we must understand that because many a time such cases are mentioned as they come up as practical questions in mains. So moving on, under the category of acceptance with condition subsequent, we must understand that if an acceptance carries a condition subsequent, it may not have the effect of a counter proposal. So it has been held in SD Catherine Stiffels versus MP Karl McCarthy, whereby an acceptance said that terms accepted, remit cash down ₹25,000 by February 5, otherwise acceptance subject to withdrawal. So where the term said this was not held to be a counter proposal, but an acceptance with a warning that if the money was not sent, the contract would be deemed to have been broken. However, in DREN International Limited versus Engineers India Limited, after invitation for and submission of tender, there were some negotiations between the parties. Over here, acceptance was communicated to the tenderer by fax stating that a regular purchase order follows. In this case, the court said that this concluded the contract. So the requirements of signatures of parties and collaborators and furnishing of bank guarantees for due performance were actually subsequent conditions. They were not like a conditional acceptance or a counter proposal. On the idea of acceptance of counter proposal, in the case of Bhagwan Das versus Sabri Diyal, it has been held that even where the acceptance of a proposal is not absolute and unqualified, the proposal may become bound if, by his subsequent conduct, he indicates that he has accepted the qualifications set up. So when a counter proposal is accepted, a contract arises in terms of the counter proposal and not in terms of the original proposal. On the idea of provisional acceptance, we must understand that an acceptance is sometimes made subject to final approval. A provisional acceptance of this kind does not ordinarily bind either party until the final approval is given. Meanwhile, the offerer is at liberty to cancel his offer. So this has been held by the Punjab High Court in Union of India versus S. Narayan Singh, whereby the conditions of an auction sale of liquor shop expressly provide that in this case the conditions of actual auction sale of liquor shop expressly provided that the acceptance of the bid shall be subject to the confirmation of the Chief Commissioner, and that there will be no complete contract till the acceptance of the highest bid is confirmed by the Chief Commissioner, and the person whose bid has been provisionally accepted is entitled to withdraw his bid. So this is a good example of the given principle, and it has also been held in Somasundaram Pillai versus Provincial Government of Madras, that the bidder will have the right to withdraw his bid even where it is a condition of the auction sale that a bid which has been provisionally accepted cannot be withdrawn. Now such a prohibition against withdrawal does not have the force of law unless there is some consideration to bind him to the condition. So we must remember the concept of consideration over here. Consideration is a very important topic which we would be discussing in the next lecture. But for now, we must understand the significance of consideration in such a principle. So when a provisional acceptance is subsequently confirmed, the fact should be notified to the offerer, for it is only then that he becomes finally bound. And acceptance is not complete till communicated. So on the idea of acceptance and withdrawal of tenders and bids, it has been held in Shetty versus Karnataka SRTC that a tender is in the same category as a quotation of prices. It is not an offer. When a tender is approved, it is converted into a standing offer. That is, a contract arises only when an order is placed on the basis of the tender. It has also been pointed out by the Supreme Court in Union of India versus Madala Thai that a clause in a tender authorizing the party inviting tenders to terminate the contract at any time for future supplies does not destroy the very basis of the contract, and that the clause is valid. On the idea of no obligation to accept tender or lowest tender, it has been held in Deepak Kumar Sarkar versus State of West Bengal, where a party inviting tenders is not bound to accept any tender, nor it is bound to accept the lowest tender. But where the party is a government or any of its agencies, it should not arbitrarily pick and choose. It should have some rules, and those rules must require reasons for departure from the normal principle to be recorded in writing. Another area of development, students, is government contracting. So, on this note, the judgment of the Supreme Court in Mahabir Auto Stores versus Indian Oil Corporation is of extreme relevancy. In this case, it was seen that the state acts in its executive power under Article 298 of the Constitution in entering or not entering in contracts with individual parties. Article 14 of the Constitution would be applicable to such exercise of power. The action of state organ can be tested under Article 14. Every action of the state executive authority must be subject to the rule of law and must be informed of reason. So whatever be the activity of the public authority, it should meet the test of Article 14 of the Constitution, and matters of entering or not entering into contract fails to satisfy the test of reasonableness, the same would be unreasonable. Rule of reason, rule against arbitrariness and discrimination, and rules of fair play and natural justice are all a part of the rule of law applicable to dealings with citizens. Even where the rights of citizens are in the nature of contractual rights, the manner, the method, and the motive of a decision of entering or not entering into a contract are subject to judicial review on the touchstone of relevance and reasonableness, fair play, natural justice, equality, and non-discrimination. So, this judgment is very important, and it would fetch you some brownie points if you would be able to quote some aspects of this judgment, the ones that deal with Indian Constitution. Now, we will be talking about Section 5 of Indian On Contract Act of 1872. So, the Section 5 deals with revocations of proposals and acceptance. A proposal may be revoked at any time before the communication of its acceptance is complete as against the proposal, but not afterwards. An acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards. So we notice that this section mentions two principles, one of which we have already discussed, the other one of which is revocation of acceptance. Now, according to English law, an acceptance once made is irrevocable. In the words of Anson, and I'll tell you why I'm mentioning in the words of Anson. So in the words of Anson, acceptance is to offer what a lighted match is to a train of gunpowder. Both do something which cannot be undone. So this rule is obviously confined in its operation only to postal acceptance. It is suggested in Anson that in other cases an acceptance can be revoked at any time before acceptance is complete, provided, of course, that the revocation itself is communicated before the acceptance arrives. So, the reason why I have mentioned these words of Anson is because in UPPCC of 2015, a question was asked, and the question said, who said that an offer need not be made to an ascertain person, but no contract can arise until it has been accepted by an ascertain person. And this statement, it was made by Anson. And this is the reason why I have mentioned this statement, because if it was asked in 2015, there's a good chance that it may even be asked in the future PCSJ examination. Now, in India, the acceptance is generally revocable. An acceptor may cancel his acceptance by a speedier mode of communication which will reach earlier than the acceptance itself, like we have already discussed. So the communication of revocation should reach earlier than the acceptance itself. So what will be the result if they reach together? Now the section does not make clear, but the only illustration appended to the section seems to show that in such a case also the acceptance will be deemed to have been revoked. And the illustration is as follows. A proposes by letter sent by post to sell his house to B. B accepts the proposal by a letter sent by post. B may revoke his acceptance at any time before or at the moment when the letter communicating it reaches A, but not afterwards. So I hope this clears the given section in your minds. Now we will be talking about the lapse of offer. So the acceptance should be made before the offer lapses, as we all know, and an offer lapses in the circumstances provided for in section 6. So section 6 says that revocation how made. A proposal is revoked, number 1, by the communication of notice of revocation by the proposer to the other party. Number 2, by the lapse of the time prescribed in such proposal for its acceptance, or if no time is so prescribed, by the lapse of a reasonable time without communication of the acceptance. Number 3, by the failure of the acceptor to fulfill a condition precedent to acceptance. Or number 4, by the death or insanity of the proposal if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. So, talking about notice of revocation, Section 5 provides that a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposal, but not afterwards. And it has already been seen that as against the proposer, the communication of acceptance is complete when it is put in course of transmission to him so as to be out of the power of the acceptor. So it means therefore that for the communication of revocation to be effective, it must reach the offeree before he mails his acceptance and makes it out of the power, out of his power. Now, a revocation is effective only when it is brought to the mind of the person to the offer is made, to whom the offer is made. So this has been laid down in Henthorne versus Fraser. And the facts of the case was says that the secretary of a building society handed to the plaintiff in the office of the society an offer to sell a property of £750, giving him the right to accept within 14 days. Now the plaintiff resided in a different town and took away with him the offer to that town. The next day at about 3:50 p.m. he sent by post his letter of acceptance. This letter was received at the society's office at 8:30 p.m. But before that, at about 1 p.m., the society had posted a letter revoking its offer. So the revocation and the acceptance crossed in the course of post. Over here, the plaintiff received the letter of revocation at 5:30 p.m. and the revocation was held to be ineffective. So this, students, become an important case law on this idea of notice of revocation, and you must cite it whenever this question is asked to you. And we would also be discussing a similar question that was asked. So on the topic of withdrawal before expiry of fixed period, we noticed that where an offerer gives the offeree an option to accept within a fixed period, he may withdraw it even before the expiry of that period. Yes, the decision of the Madras High Court in Alfred Shublank versus Muthunya Chette is an illustration in point. So over here, the defendant had left an offer to sell a quantity of indigo at the plaintiff's office, allowing him 8 days' time to give his answer. But on the 4th day, however, the defendant revoked his proposal. The plaintiff accepted it on the 5th day. Holding the acceptance to be useless, the court said in this case that both on principle and on authority, it is clear that in the absence of consideration for the promise to keep the offer open for a time, The promise is mere nudum pactum. So we notice over here that where an offerer gives the offeree an option to accept within a fixed period, he may withdraw it even before the expiry of that period. And that is why the promise here is mere nudum pactum. And in 1991, the question 9B in UPPCSC examination was asked, and the question said, on April 10, 1990, A offered to B to sell his car for 60,000 rupees. B was asked to signify his acceptance by April 18, 1990. And on April 12, 1990, A sold his car to C for 70,000 rupees. This he did without revoking his offer to B. However, B came to know of this fact through other sources on April 14, 1990. Now, the question here was that has this resulted into a binding agreement between A and B? So, students, if you were to get a similar question again in your examination, what you must do is that you must mention firstly the difference between English and Indian law. In that Indian law, under Indian law, the cancellation of proposal can be done by the proposer or his agent after informing the second party about cancellation. But under English law, the information of cancellation made through any source to the second party will be sufficient. So, according to section 6, the proposal can cancel the proposal after giving information. It is also the rule of law that if the proposal gives any definite time period for acceptance, then before the end of that time period, he is completely free to cancel the proposal. However, and this is important, in section 6, subsection 1, it is clearly mentioned that the information regarding revocation or cancellation should be given to the second party by the proposer, and therefore acceptance of proposal by B will be effective and thus become a binding promise between A and B. This is how this question was to be solved, and I hope that this helps you in the future questions that may come on similar lines. Now, on the idea of agreement to keep offer open for specified period, where the agreement to keep the offer open for a certain period of time is for some consideration, the offerer cannot cancel it before the expiry of that period. So in Mountford versus Scott, whereby the owner of a house agreed in consideration of the sum of £1 to give the plaintiff an option to purchase the house for £10,000 within a stated period, he was not allowed to revoke the proposal within that time. £1 was a sufficient consideration because it was valuable. So the effect was that the offer was irrevocable for the specified period of time and the offeree could accept it notwithstanding the purported revocation. On the idea of communication of revocation being from the offerer himself, now it is of course necessary that the communication of revocation should be from the offerer or from his duly authorized agent. But it has been held in England in Dickinson versus Dodge that it is enough if the offeree knows reliably that the offer has been withdrawn. Now we must understand that it has been suggested in Pollock and Muller that this rule will not be applicable in India for the simple reason that subsection 6.1 requires in so many words that the notice of revocation should be by the proposer to the other party. So we must remember that the Indian position. Now on the idea of revocation of general offers, where an offer of a general nature is published through newspapers, it can be withdrawn by the same medium and the revocation will be effective even if a particular person subsequent to the withdrawal happened to perform its terms in ignorance of the withdrawal. So to put things in perspective, in Subay versus United States, the announcement through newspapers of a reward for reporting certain criminals was withdrawn by a subsequent notification. But a person who was working on the track of the criminals detected and reported them. Now he was absolutely unaware of the revocation. He could not recover. So it was withdrawn through the same channel in which it was made, and that was the reason why he could not recover. On the idea of superseding proposal by fresh proposal, it has been held in Bank Paribas versus Citibank NA that where before acceptance a proposal is renewed in some parts of it and not in its entirety as proposed earlier, and the letter purports to supersede the earlier communication, such proposal is no longer available for acceptance. Thus, the acceptance can be only of the renewed part. So, this covers the entire context of notice of revocation. Now, coming to the second sub-point of this section, lapse of time. An offer lapses on the expiry of the time, if any, fixed for acceptance. But when an offer says that it shall remain open for acceptance up to a certain date, it has to be accepted within that time. And the same has been suggested in Brunner versus Moore, whereby it was held that in such a case it is enough if the acceptor has posted the acceptance before the stipulated time, even if it reaches the offerer after the stipulated time. So, the court said that an effective date on which the option of acceptance is exercised by a party is to be ascertained from the date when the acceptance is put in transmission and the letter is posted. Now, coming to the third sub-point, that is by failure to accept condition precedent. Here we must note that where the offer is subject to a condition precedent, it lapses if it is accepted without fulfilling the condition. And the same was held in state of West Bengal versus Mahendra Chandra Das, where a salt lake was offered by way of lease on deposit of a sum of money within a specified period, and the intended lessee did not deposit the amount for 3 long years. So it was held that this entailed cancellation of the amount of the allotment. So that was there, and this case is important because many a time we notice that this provision is asked, a scenario where a condition precedent was failed to be accepted. So, state of West Bengal versus Mahendra Chandra Das. Now, coming to the fourth sub-point, that is by death or insanity of offerer. So, an offer lapses on the death or insanity of the offerer, provided that the fact comes to the knowledge of the offeree before he makes his acceptance. So this must be understood as it is written exactly. And a question has been asked in UPPCSJ of 2006 in the prelims that a proposal is revoked, A, only by the death or insanity of the proposal itself, B, by the death or insanity of the fact of the death or insanity comes to the knowledge of the acceptor, and C, by the death or insanity of the proposer if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. And this was the correct answer. So lastly, as a part of this lecture, we would be discussing section 9 that says promises express and implied. Insofar as the proposal or acceptance of any promise is made in words, the promise is said to be express. Insofar as such proposal or acceptance is made otherwise than in words, the promise is said to be implied. So, a contract implied in fact requires meeting of minds. The courts have to refuse to read an implied term into a contract which is silent on the point or did not clearly indicate the nature of terms. So, you must have remembered this given dialogue, this given statement. It was mentioned in one of the case laws, and you can tell me the same in the comment section. Now, it was held in Upton on 7 RDC versus Powell, whereby a fire broke out in the defendant's farm, and he believed that he was entitled to the free services of Upton Free Fire Brigade and therefore summoned it. But the brigade put out the fire, and it then turned out that the defendant's farm was not within free service zone of the Upton, which therefore claimed compensation for the services. So these were the facts, and the court held that the truth of the matter is that the defendant wanted the services of Upton. He asked for the services of Upton, and Upton, in response to that request, provided the services. And hence, the services were rendered on an implied promise to pay for them. In another case, that of Ramji Dayawala and Sons Private Limited versus Invest Import, it was held that whereby the facts were such that a contract was signed between an Indian and a Yugoslavian party, one of the terms provided for arbitration by the International Chamber of Commerce in Paris, and immediately thereafter the Indian party cabled and also wrote its objection about the arbitration clause, and the other party made no reply to it but permitted the work to go on. So a dispute having arisen, it was held that the arbitration clause had become deleted from the contract by an implied agreement. So a suit could lie in a court of law. Now, a question was asked in UPPC's J examination of 2015, question 2C of mains. The question read, how can an offer be made, revoked or accepted? What rules apply when an offer is made through post or over the telephone? So students, as you must have realized, in this question we were supposed to start with section 2A, then talk about section 6, and then finally conclude the answer with section 2B. So students, this sums up the second lecture of the certification course on law of contracts, as a part of which I have finished the first chapter of the Indian Contract Act of 1872 with you. I hope that you found this useful. Please go on to read and revise from the PPT, and the same must be helpful. Thank you till we see each other again.